All right. Good morning, everyone. Welcome to I don't know what to like outside in terms of the weather. It's freezing outside, but it's supposed to warm up. Last night was really cold. I know that obviously I deal a lot with individuals experiencing homelessness, and I worry about all those individuals out there. But it was very cold. I think it's supposed to warm up today and warm up tomorrow. I think we're going to have some pretty good weather for the next couple of days. It's going to be in the 30s at night, but the weather's going to warm up. So anyway, looking forward to a little bit warmer weather for everybody. Our guest today is Judge Jennifer Smith. She's out of Criminal Court Division 4. Welcome, Your Honor. How are you doing today?
I'm doing wonderful. I'm glad to be here.
Good. Well, we usually take a couple minutes to get started, and then I ask something irrelevant about something that's sitting behind your head. There's something behind your head that has a lot of color on it. Can you tell me what that is? That thing. Yeah.
You're looking at that.
Yeah. What is that? That
is a row of race medals that are hanging over my treadmill.
Oh. Did you buy those? Did you buy that or?
Yeah, you can get them on eBay. No.
Really? Can you?
No,
okay.
I'm just kidding. No, I enjoy doing races and of various sorts. Kind of keeps me fit, and I don't run very fast, but I figure if I at the starting line and at the finish line, I've done something.
Well, so tell me a little bit about those medals, because I have some of those. I don't have as many as you do. So do you run 5Ks? Do you run half marathons? Do you run marathons? What do you run?
Mainly half marathons.
Mainly half marathons.
But it's most of those are half marathons, but there are a few 10Ks and look, there's a couple of 15Ks up there. You know, that the hot chocolate race, I think was in Nashville a couple of weekends ago. Did that one, but it's it's just fun. I'm not competitive.
Okay, so that's what I do. So I've run 9 half marathons.
Oh, fun! Yeah.
I'm supposed to be training to run the one in April.
I'll be doing that too. Yeah.
I'm not doing a very good job, and I run very, very slow.
Yes, I kind of run. I kind of walk. Kind of,
the voice is on here. I just unplugged it.
Oh, so get everybody to. I'm getting everybody to mute for a second. So, Your Honor. So when you, I run very, very slowly. Okay. Mm-hmm. I mean, some people don't even consider it moving forward, but I do run slowly. But there's such a, I really like doing it.
Yeah.
I mean, first of all, I like training. I like going outside and running because I can put headphones on and no one's bothering me. I can kind of just get away from all of it. My biggest problem is that when I run, I see people I know and I stop and talk to them for a little while. Exactly. And it's like it takes me forever to run. The half marathon, let me ask you a question. This is very important. So I tend to run by myself. Mm-hmm. I mean, obviously I don't run with a group because I run slower so I can run at my own pace. My biggest issue, and I've been asking people about this, is that I put in my set of headphones, but there is so much noise and stuff going on that I can never really listen. Somebody said I needed to switch and get some noise impact earphones. Do you run with those?
I don't. I'm really very low tech. I'm a low tech person all around. So I still have the the $10 things that with the big wires that you stick in your ears.
You're sort of like me. So you're cheap like me.
That's right.
You're cheap like me. I have an iPod that fits in my pocket and runs up and I put stuff in my ears. But that's what I can hear everything else that's going on. So the whole 16 days it takes me to run the half marathon, I'm listening to all this stuff.
Yeah, that's me. I'm pretty low tech, and the bad thing is my phone is so old that my battery tries to run down before I finish the race. That's how slow I am. I can't keep my battery charged. So
well, the battery in my in the golf cart that I drive around in to finish the half marathon always runs out as well. So no, it's really fun for those of you who have never done that before. And I talk to a bunch of people and they go, I can't ever do that. And I can barely run 20 feet. You can if you just work at it, and you build yourself up over time, and then you start increasing your distance, and all of a sudden you are running 5-6 miles at a time, and you can do it. And it's really, I would always encourage people, as long as they're healthy and and get checked, to try and do one, just for the sake of doing it, just to see if you can. And then even if you get tired,
too, yeah. It's a lot of fun. People are excited. A lot of different. You see everyone. All ages and shapes and sizes and fitness levels, and it's just fun. Especially the local races. You go through town, and people are so. I don't know. You've probably done this one. The one that's coming up in the spring. You've probably done this one before, but I love running down Belmont Boulevard, and people come out in their front yards and, with all kind of, water, and, they're in their chairs and cheering you on, and it's just fun. It's fun to connect with the community.
It is. It's a great thing to do. And Joyce McDaniel, who helps me, usually is out there somewhere. And one time I think I was running by and she offered me, I think, an alcoholic beverage. And I said, I'm having enough trouble finishing it right now. So anyway, that's coming up April the 23rd. All right, so welcome everybody. I've gotten a lot of really good information from the judge about running. We have Judge Jennifer Smith, Criminal Court Division 4. Her name will be on the ballot this time, but it's my understanding, Your Honor, that you have no opposition.
I am gratefully that unopposed and really love the work, and it's so rewarding, and talk about connecting to the community. Criminal court really allows you to do that. I see a lot of people every day, and it's just the best job, because you're able to get in and make a difference in people's lives. And I hope that the fact that I don't have an opponent means that people think I'm doing an okay job. I've been in the job now for a few years, and try to always trying to look at ways to be better at what I do, and but really enjoy the work.
Well, if it makes you feel any better, and I told you this before we got on the air with everybody, I'm at an event right now where there's about 35 people who are running for all the different judicial things that are open right now. And the hardest part is, and I would tell everybody on this call who is listening today or who watches this, that it may be better to get a sheet that tells you all these different judicial races, because there are a lot of races, a lot of contested races. And you almost need a sheet to try to keep, it's like a scorecard to try to figure out, if you're listening to somebody and you go, you know what, I really like that person's story or whatever, you can at least check so you remember kind of where they are on the ballot. So anyway, that's something that we're going to be working on, because these races are very important.
They really are. And there are there's so many, every judge is up for election. And I don't think people this is a big county, and we've got six different, 6 criminal judges, trial court judges. 3 of those elections are contested. There are, I believe, 8 circuit court judges, and I think at least 3 of those are contested. 4 chancellors are up for election. One of those maybe is contested, and I think 11 general sessions judges, and a number of those are contested. So there are a lot of judges, and everybody is up for election this year.
Well, I think we need to regroup. I'm thinking through this about how we make it easier for voters going into the polls to know what these, first of all, what are these positions that people are voting on, and who they are. So they can figure out what the positions are. Maybe they can drill down and figure out who's running and figure it out that way. Let me get started with, I usually ask the first question, but I will say that Councilmember John Rutherford is on. Welcome, Councilmember Rutherford. Thanks for being with us today. Your Honor, the first question I ask all my guests is, tell me a little bit about yourself. where were you born? What have you been doing all these years? And how did you what was your path to becoming a judge?
Well, I was born in on the coast of Mississippi, in Pascagoula, Mississippi, and grew up there. Lived there, all of my childhood. Went to Ole Miss undergrad, Ole Miss Law, really because I didn't know what I wanted to do until the very last minute. I decided I had an English degree from Ole Miss. And there's only a couple of things you can do with an English degree, which is, you can teach school, and I didn't have any education classes, or you can go to graduate school in English, or you can go to law school. Those are the choices. So I decided to go to law school at the last minute.
And did you flip a coin? Is that what happened?
Yeah, kind of. I never really had a burning desire to be a lawyer, but graduated from law school and actually practiced down in my hometown for a few years before moving up to Nashville. Had some friends that moved here, and everybody was kind of migrating. Even back in 1994, people were migrating to Nashville. So I joined the migrant crowd and came up here and landed in the Attorney General's office because I had friends here, and they kind of introduced me, and I sent a resume in, and so was glad to get a job. Worked there for a few years and sort of left, and was in private practice for a little bit. Doing some criminal defense work, worked in the juvenile court for a little while, was actually a Metro guardian ad litem, the first Metro guardian ad litem when Carl Dean was the public defender at that time, got a grant from the council for that. And so I went to work in the public defender's office. I went back to the AG's office and just worked my way up the ladder there. So at a certain point I guess it was in 2018, Judge Seth Norman announced his retirement, and had never really thought about being a judge, but kind of thought, well, I've been doing criminal law for a long time. Maybe I ought to put my name in the hat, and got lucky, got picked up for the seat, and been doing that since then.
So tell me, all right, so from Mississippi, did your schooling in Mississippi, went to Ole Miss Law School, but you also had some military service, correct?
I'm in the military now. I'm in the Navy Reserve now. I've been in since 1999. I was commissioned as an ensign in 99 as an intelligence officer. I was actually already practicing law. I was working in the Attorney General's office then, and I guess when I was younger, I had a little bit of, you kind of get restless, and I was working and thinking, oh, you're looking around thinking, what else can I do? And you knew someone in the office that was an Army reservist, and he said, why don't you look into the Navy Reserve? You might enjoy that. So I talked to a recruiter and picked up the Navy had and still has a program called a direct commission officer program. So what that is for certain professions in the Navy. A lot of the medical professions, doctors, nurses, engineers, public affairs officers, and attorneys and intelligence. They have a program where they will directly commission you, meaning you don't go through officer candidate school, you don't go through ROTC or any of the sort of the standard pathways, because you have certain civilian skill sets that they need. And so I applied for that program, not in the legal field, but in the intelligence field, because at that time, the intel field was recruiting pretty heavily from the legal community, because it's a similar skill set, doing intelligence analysis and legal analysis. So,
and can you tell, without giving any military secret, what does that mean? When they want you to do intelligence, can you generally tell us what that means?
Intelligence is taking information from a lot of different sources. Whether it's human intelligence, what someone observes, or signals intelligence, intercepting communications, imagery intelligence, just pictures of things. You take information from a lot of different sources and you pull it together and analyze it and assess it, and you make assessments and or predictions about either how someone's going to behave, what an enemy's military capability is, where they are, what they're doing. So you're drawing conclusions from incomplete information and trying to make an assessment about something you don't know. I don't know if that makes sense, but you always have incomplete information, and you're trying to sort of put that together and make an assessment about something that is important to the commander.
So did you have, when you joined that, was it something that was like, I'm interested in doing that type of work? How did you think all of a sudden, I mean, obviously you're practicing law, and all of a sudden you're going like, that seems kind of interesting. I'd like to do that. How did you figure that one out?
It was just kind of like that. It was kind of just like that. I said, "Oh, that seems kind of interesting. I think I'd like to try that." And so I did have an option of going JAG, and I just didn't want to do the same thing in my off time that I was doing every day, and I want to learn do something different. I like trying new things, and I never expected to be in as long as I am. I thought I'd do it a few years and just move on to something else. And I've been in it, and in fact, sort of, it to me, it's a career as important to me as my legal career. I've been in it now for over 22 years, and I'm a captain in the Navy now. I'm commanding my third intel unit. So I've enjoyed the career and still enjoy it.
That's so interesting, because obviously we're in positions where we provide services to the public. We're in the public service field. And so there's obviously, people ask sometimes why we're in it. And it's like, I think you have to hopefully have a passion for doing it. But I also worry about, I'm looking at what's going on in the world today, and it's like, how people sometimes feel so helpless, because, we don't have much say in what's happening here. The best you can do is vote, but unless you're involved or engaged, sometimes you feel like there's, what are you supposed to do? So you committed to doing something else, which is really interesting. Well, if somebody's listening to this and are interested in at least looking at this as, because it's not a full-time, it's something that you do as a reservist, how do people get engaged with that?
People who are interested in serving, and I think the reserve services is something that I always encourage people, especially I've encouraged many young professionals to look into it, because I think people want to serve. People want to, people are interested in public service and are always looking for ways to engage. But if you're interested in going to any kind of reserve service, you start with a recruiter. If you have a college degree, then I recommend that you start with an officer recruiter. Most recruiters that you walk into just in a storefront recruiter, those are generally enlisted recruiters. So, for kids in high school or kids working their way through college, I've got a lot of kids in my unit. I call them kids because I'm getting old now. They seem like kids to me. They're as old as my own kids, but got a lot of members of my unit who are college students, and they don't have to do what they do. I'm inspired by them because, they don't make a lot of money. The military doesn't pay a lot of money. It's a huge commitment, especially for intel. It generally involves travel every month because you're limited in the locations that you can serve. But, they come to drill one weekend every month. They commit to a minimum. It used to be back in the old days when I started, which was before 9/11, it was, the standard 1 weekend a month, 2 weeks, two weeks every year. And that was kind of their selling point. It's not that way anymore. The reserves the military services rely very heavily on their reserve components, and they're constantly pressuring folks to go on much longer term orders, longer than 2 weeks. A lot of the folks in my unit have gone on, year-long orders. I myself have been mobilized twice as a reservist, once into Bahrain back in 2003, at the beginning of the Second Gulf War. And then I spent a year in Afghanistan in 2011-12. So, it is a big commitment, but, I tell folks that, less than 0.5% of people actually serve in the military. Less than 1% of the citizens of this country are defending the country and are going forward and doing the things that we see the military do. You could put the entire Navy Reserve force in the UT football stadium. That's how many.
You talking about in the country?
Yes, the Navy Reserve. Yes, will fit in that stadium. So there is a small percentage of people doing a huge amount of work. So yeah, and I don't, I don't know why I keep doing it, except that when because when I'm not in uniform and I'm trying to juggle my schedule, sometimes I grumble a little bit about trying to juggle everything. And then I put the uniform on and go and start working in the unit and work with amazing people who are doing amazing things and sacrificing and juggling just like I am, and you just get inspired.
All right, so I'm going to ask you one more question, and then we'll get into the judges race. But I find this so interesting, and I'm so proud you did it. I in some ways, I wish maybe I had looked at it and seen that as an option as well, because I want to be of service. Mm-hmm. And so I guess my question is, as we look at what's going on in the world today, I think there's this feeling of helplessness, and just watching it unfold, and particularly with the modern technology and social media, you're watching the meeting I just came from. I said I had gone to see the Predators play on Thursday night when we honored Pecorino, which was such a nice event and such a good thing for a person who's done a tremendous amount of good for the city. Mm-hmm. And then I come home, turn on the television, and I see families hiding in a subway in Ukraine. And I think we all look at, it's like you feel so helpless because you don't have much control over it. From your standpoint, again, without really telling us anything that you're doing, I mean, do you get the same feeling? I mean, you're actually more involved in this, but I worry about, first of all, you worry about what's going on, and then where it could go. And so what are your your general feelings on the whole thing?
I mean, I worry just like everyone. I guess the big difference is that a lot of times when these things, when these conflicts began as a reservist, the first thing you're thinking is, is this going to be something that's going to involve, augmentation of the active duty force and those types of things. Right. So, I mean, you think about that, but that's why we have a reserve force, and everyone that serves as a reservist knows that that's why they're there. I mean, that's the reason that we do it. It's not just because we want something to do once a weekend, once a month. You prepare for it the best you can. But yeah, it's very, I mean, what's happening is very disturbing to me, just as a citizen of the world. You don't expect to see a conventional ground invasion in 2022. I mean, you expect things like, cyber attacks and things of that nature, which we've seen more of in the modern era. And certainly, the intel field is sort of shifting a lot of focus, toward that. But, this is is pretty shocking and disturbing. So,
well, someone this morning on, I think I was listening to CNN on the way as I was driving, and they said entities are being told shields up, particularly from a cyber security type thing. And it's like everybody, it's like everybody to their stations. It's like, put your shields up because you kind of, I don't know where we go from here, but the concern about I think it was a guy who spends time thinking about all these different things, but you don't know what could happen, and so everybody just needs to be cognizant that there could be disruptions of not only goods but also systems as well. And it's amazing to me that one individual can basically start changing the course of how we do things and make and create turmoil through the world. But that has obviously happened before. So
yes.
So, okay, so let's get off that. Really interesting. Thank you for talking to me about it. I thought that was really, really interesting, and I appreciate what you do. So you were in the Attorney General's office, position pops open, and all of a sudden you decide that you want to be a judge. All right, so tell people who are listening the process that you had to go through, first of all, to be selected.
So the process so all of our judges are elected for 8-year terms. So if a judge and this is the state at the state trial court level, so criminal court, circuit court, chancery court, a trial court level, if a judge leaves the position by retirement or for some other reason before the end of that term, the governor will appoint an individual to fill that position, and then that individual has to run again in the next general election. So it's an elected position, but the governor will appoint someone to fill the position until the next election. So that's what happened with the seat that I'm in. Judge Seth Norman retired before the end of the term. At that time, Governor Haslam then was tasked with appointing. So the way the appointment process works is there's the AOC will put out an announcement that there is a vacancy. Interested individuals will submit a written application. It's a lengthy application that is, there's a deadline to submit. It's, that application is submitted. It's posted online for everyone to see. Then whoever, all of the applicants will then appear and be publicly interviewed by a commission. I can't remember how many. I think there are maybe 9 or 11 members of the Judicial Selection Commission. So that those interviews generally happen. There's a date that's for the interviews. They're public interviews. Then the commission will select 3 people from all of the applicants, and those 3 names go to the governor, and the governor will then has his own process to make the selection from the 3 that come out of the commission. So it's for Governor Haslam, there's a TBI background check. He did interviews and, he has his own process. And I think it's just individual to the governor, but that's how that process works.
Okay. So you became a judge, and I know then you had to run. Tell me about, it's Criminal Court Division 4. Mm-hmm. Tell me about what you do on a daily basis. And is there anything unique about your division, unlike some other divisions that are also criminal court?
Right. And I did have to run, by the way. And so when I was appointed, the next election was in 2020. So I actually ran.
Yes, I know.
In 2020. But now I'm up for election again in 2022 for the full term. But
yeah, and because I'm talking to you, you won that election. So yes. So now you're the judge. That's true. Okay. So tell me about what you do. What is Criminal Court Division 4? What do you do? And then any unique things about the division itself?
So Division 4 is like all of the other divisions. We all handle criminal cases that have come up through the grand jury. So anything that's been indicted and that will be, could potentially go to a jury trial. And that can be any from misdemeanors, DUI, petty theft, misdemeanor theft, all the way up to first-degree murder. We have, criminal jurisdiction. Again, anything, the cases come to us after the grand jury indicts. And so then they're assigned based on the date of the commission of the offense to the various, the 6 criminal courts. So my court is just like all the other courts in that respect. The only thing the one thing that is unique to Division 4 is that Judge Norman, my predecessor, established a drug court and eventually a residential drug court to deal with individuals who come into the criminal justice system by reason of addiction. And so in addition to doing my regular criminal docket, I also oversee the Davidson County Drug Court. And you call it a drug court. I think now more often you're hearing the term recovery court. And so I also, I will oversee that. We have a residential facility out on County Hospital Road. Right now we have about 50 people in residence. We generally have around 75 folks in residence, but our numbers reduced significantly during COVID because we had to slow down our intakes just to protect our residents and staff. But yeah, that's different. I say that it's unique to Division 4. Division 2, Judge Angie Dalton's court is also about to begin a separate residential recovery program that is unique to women. It's specifically a women's recovery court. And I think she is going to begin that in March. So it's just about to open. DC 4, which is my recovery court, is a co-educational, co-ed. We have men and women. It's 2 separate programs. They don't intermingle, but our facility houses men and women. But it's it's an amazing program. I'm really proud to be a part of it. And is recovery courts are really important, I think, to get people back on track, get their lives on track, let them, help them to get a handle on their addiction, which is so often the driving force for a lot of the criminal activity.
Okay, so tell me, I guess to try to figure out how all this works. So certain cases go directly into General Sessions Court, which you are not.
Right.
You're a circuit court level.
Mm-hmm.
So a lot of the stuff, a lot of the smaller things, the misdemeanors and other things will be handled by General Sessions Court.
Mm-hmm.
Correct?
That's correct.
Okay.
So the General Session, if you can have a trial, if you're charged with a misdemeanor, you can have a bench trial in front of a General Sessions judge, and they can handle that. Okay,
but the cases again that are showing up in your court are
Mm-hmm.
coming out of being reviewed by the grand jury.
Right, and it's so when someone is arrested, anyone who is arrested for a crime is going to initially go in front of the General Sessions Court. And the General Sessions Court at that point will conduct what's called a preliminary hearing to determine whether there is sufficient evidence for review by the grand jury. And so they will have a hearing that really, it's largely one-sided. If the state can make a basic case against the individual, if there's probable cause to bind it over, then it's a much lower standard than a trial. But then the General Sessions judge will bind that case over to the grand jury, and the grand jury will then consider it. If there's not an arrest, if the district attorney just has information about a crime being committed, the district attorney can directly present a case to the grand jury, and it will never go in General Sessions Court. It'll just come directly to criminal court on a directly presented indictment. So, but most cases come through General Sessions Court.
Okay, so everything goes to General Sessions Court, a lot of stuff gets determined in general sessions court and gets resolved, gets settled, whatever.
Right.
So those cases, so you have all these cases coming through, and a number of them go this way, get handled by general sessions court, and are taken off. Take a more serious case, a homicide. Comes in front of a general sessions court judge, and then if this, assuming there's enough evidence to say, you know, there's a homicide, we believe this is the individual, it then goes where? It goes to the grand jury?
It goes to the grand jury. And then the grand jury then makes the determination of whether there is probable cause to indict. And that and the indictment is the formal charge. So the case gets to general sessions court because there's been an arrest. So the formal criminal charge, and generally it's an arrest on a criminal complaint of some sort. But the grand jury will actually do the formal criminal charge that initiates the criminal case. So then it comes to the criminal court and goes through the process there. Okay.
So so the grand jury meets on a regular basis during a set time, and they're reviewing these cases as they come through, and they're making a determination whether they believe there's probable cause to move the court through, to move the case through. And then because how many district courts, how many criminal court divisions do we have?
There's 6.
6. So the cases, I know like in Chancery Court, it just is when you file, they'll go to certain places. Same thing with criminal court coming out of the grand jury. Do they just go, okay, so this next case goes to Division 1, the next case goes to Division 2, or is somebody making a determination to say, you know, because of it's a nature of a drug court type case, it goes to Division 4? No,
the assignment by division is based upon the offense date or the arrest date. I'm sorry, there's the arrest date, which generally is close to the offense date. So we've got a chart. So the criminal judges have a schedule. And so we can tell which cases are coming to us if they are indicted based upon what that schedule is.
Okay. And so I assume the schedule is designed to try to evenly balance out the number of cases that are being heard.
That's correct.
Okay. And then for people who have never been to a criminal court division, so there's a case that's now, it's been over the grand jury finds probable cause, and it shows up, it comes over to your court. Tell us kind of the process. Obviously, we don't get into individual cases here, but the typical process for a case that would then all of a sudden you find out a case that's been assigned to you, where does it go from that standpoint?
So every criminal case has pretty much the same lifespan. It comes to me. So once it is indicted, and I know it's coming to Division 4, within just a couple of weeks of the indictment, that case is set. First of all, the individual is served with the indictment, is arrested on the indictment, or served with the indictment. Then they are set to come before me for what's called an arraignment. And at the arraignment, the individual who is charged will enter a plea. And generally that is a not guilty plea. A lot of our cases come from people who are not able to afford to hire counsel. So at that arraignment, the individual will provide me some financial information. If they qualify for appointed counsel, I'll appoint counsel at the arraignment and give the attorney or the retained attorney will appear. But I'll give them at that time a schedule, basically a case management schedule, which will have some deadlines for discovery or the exchange of information. There will be 2 deadlines, 2 court dates set for what's called a discussion. And those are specific dates where the individuals will come and lawyers will talk to determine whether there can be a settlement of the case, a resolution of the case. We generally do a first discussion and a final discussion. And then after that, the case is set for trial. So, it's a pretty straightforward process. Sometimes, things are extended for various reasons. If there are missing documents and things that maybe the DA is trying to gather some additional information that might be helpful for for settlement discussions, and vice versa. The defense counsel might find that, if they can provide some additional information to the state, it might facilitate settlement. But ultimately, we're moving toward getting the case set for trial and disposition. The vast majority of cases will settle.
Yeah, I was going to say, so two questions. One is the percentage. Do you all keep an idea of how many cases that are coming into your case actually get settled before they actually get to an actual trial?
Yeah, I'm sure someone keeps those figures. I don't have a number on the top of my head, but I can tell you just anecdotally, it is the vast majority. I mean, I would say, probably 90%, just based on what I see.
And the parties come together and they come before you and say, Your Honor, we have worked out a settlement. This is what it is. And
right.
Then do you have to sign? Then you sign off on the settlement.
Well, if there's by settlement, I mean either the individual will enter a plea either to the charge defense or to a lesser or amended charge based upon whatever the discussions yield, or they're vice versa. But on the other hand, the state might decide they're not going to go forward with the prosecution, so they might announce that they're going to nollie the case or nollie prosecute the case, which means they're not going to pursue the case and it would be dismissed. Sometimes, if it's a sort of a minor offense, the state might decide to retire the case for a certain period, retire it for 6 months or a year. And if the individual stays out of trouble, they won't pursue it. They'll just dismiss the charge. So there are a lot of different ways the cases can be resolved. It's all, it's all case by case, but most people who are charged or indicted end up pleading guilty to, if not the charged offense, a lesser offense.
Okay. And then is there typically with the determination, if they agree to a lesser charge or whatever, is the actual sentence, the punishment, time served, is that presented as part of the agreement that's brought before the court?
It can be. The sentence can be part of the agreement, and the court, the trial court has to approve it. I mean, if you have an agreement, the trial judge doesn't necessarily have to accept the agreement. Most of the time, the court will accept the agreement if the state is recommending a sentence. But part of the plea, so I've got to determine a couple of things. When someone comes in and pleads guilty, number one, they have to admit that they're guilty. And the state has to present a statement of the evidence that it would have presented if it had gone to trial. And so from that statement of evidence, I, as a trial judge, will determine whether there is a factual basis for the guilty plea. I mean, you can't just plead guilty to something and there be no basis for it. So I have to make a determination based upon that statement. Does this establish the crime that the individual is pleading to? And then you assess whether or not you find the sentence is appropriate, and you can accept that recommendation and impose that sentence. Or there are times as well where the parties will agree to a guilty plea, but they can't reach an agreement as to the sentence. And so I will then set a separate sentencing hearing, and I will impose sentence based upon whatever. And the parties will make their various arguments, but it's not unusual for the parties to agree that a guilty plea is appropriate, but not be able to agree on a sentence. And that'll be something that I would determine separately.
Okay. So tell me, so move away from that one. Let's say that you've got one that won't, either because of the nature of the case or because of the parties or whatever's going on, there is no agreement to try to work the case out. Typically, how long before, and I know it varies because, I mean, sometimes there's you've got a very public case, or there's a tremendous amount of evidence going on. But typically, how long would it take from the time that it ends up in your court with no agreement by the parties before it gets to a trial before your court?
I would think so. If I had a case that was arraigned this week, probably under the scheduling order, the final settlement date would probably be sometime in June. They would probably have an April or May discussion date, and then probably a final discussion in June. If they couldn't agree after that, then they would look at the trial calendar. And our trial calendars are now running. I mean, I'm setting cases now at the end of the year in sort of, October, November, December. So in June, I would think, they'd probably be into 2023. So it could be a year and a half or so.
Yeah.
If everything
so
was on schedule.
So it takes a while. So the immediate question that I know somebody's going to ask is about people making bond, people, because that may be a long time.
Right.
So if you don't mind, quickly, for people's benefits, somebody is picked up or arrested and brought into, I think they would typically, I assume, initially go through a night court judge. And then, so bail is set. How does that process work all the way through, from the initial arrest all the way to when it gets to your court? How is basically a bond determined, and how often could it be changed on the way up?
So the bond, as you said, is generally set at the night court commissioner level. And I think at that level, I'm not sure the exact process that each commissioner uses, but but in my observation, they have certain set amounts for various levels of offenses. I mean, I tend to see, if you've got like a C felony, you're going to see anywhere from a $10,000 to $20,000 bond on a C felony. So I think, and it kind of goes up and down from there. That case is then, as we mentioned earlier, will go into the General Sessions Court for a preliminary hearing. Very often you will see defense counsel ask the General Sessions judge to modify the bond. They may or may not make a modification based upon their examination of the evidence, because, the strength of the case is a significant consideration. And so that's really the first time that a judge has an opportunity to see the evidence that the state has. So you might see a modification at that point. Once the case is bound over, if the defense counsel still is dissatisfied with the bond, then they can immediately at that point come into criminal court and ask for a reduction or modification. It doesn't even have to be bound over, because they know which division it's going to come to. So they're going to file it in the court that it's going to ultimately end up in. Right. And at that point, and I hear a lot of these, so they'll bring in, the statute has certain things that I consider that the court should consider, or that a magistrate or judge should consider, including, ties to the community, or, the length of residence in the community, your financial resources, background, personal background, character, any kind of mental illness, those types of things. And then as well, the strength of the evidence, the nature of the offense charged, the potential sentence, and the nature of the offense as it bears on the potential sentence. Because if you've got someone who's facing, a life sentence on a homicide, that provides an incentive not to want to follow through with that prosecution. So the goal of bond is, number one, to assure someone's appearance in court, to answer the charges, and as well to protect the safety of the public. So in looking at the safety of the public, you look at obviously the circumstances and the strength of the evidence of the crime charged, but as well an individual's criminal history, whether or not they've got a history of violent offenses and extensive criminal history, those types of things. Anything bearing on public safety or on the risk of appearance in court. Someone may have a history of not appearing in court, and that'll bear on the bond. But it's kind of one of the things that I find frustrating. There's not a lot of guidance on setting a dollar amount, and I've struggled with bond issues over the years, because it seems very arbitrary. I mean, you see individuals charged with homicides that you might have a very high bond, $250,000, right, $300,000, $500,000. In other cases, it might be as low as $50,000. But again, it's a case-by-case determination, and you just try to make the best call that you can. The things that I tend to look at, again, are public safety issues, an individual's criminal history, an individual's history of appearance, the nature of the particular offense, the strength of the evidence. Because you do make an assessment, and you hear the argument about the presumption of innocence, and there is a presumption of innocence. That is a trial presumption that the jury has to apply. But for bond issues, the trial court is required to look at the strength of the evidence and to make an assessment about the likelihood of conviction. That's part of the bond calculus. So we consider all those things, but bond is a tough call. And in terms of, how often it can be considered, I've had people come multiple times, especially if a case gets continued over and over and is not set for trial for a long time. They might come back and say, look, he's been in custody now for a significant period. Maybe we should reconsider that. So we've got about 8 minutes left. So I got 2 more questions for you. And the first one, the problem with talking to a judge is that you obviously can't get into cases and everything else like that. So I'm always careful when I ask a question because it may be something that, pursuant to judicial guidelines, you can't do it. But I've had a couple of questions today about reform in the process. Mm-hmm. So whether it's, bail reform, whether it's something else going on. And I think the question said, look, your term would be for 8 years, correct? That's correct.
That's what it is. So, mm-hmm. and 8 years is a good term. I know there's a reason why it's built in there, but how do judges, or how can judges, if you see as you're going through these things and you see something that needs addressing, a reform, something that is showing up that is like, I wish it could be something different, or, I wish we had more guidance on this type of thing. How do judges do that? How do you get, typically the legislature will go, we want this and this and this, but you all are judges. How do you reform the system to try to make it better? And how do you get that information? So if somebody comes in and goes, I just didn't think this was the right way to do it. Mm-hmm. You all are listening and are going like, you know what? Maybe somebody ought to take a look at that. How does that work?
Well, it can work. It can work in any number of ways. We're judges. We're also citizens, and so if we think there's an issue that needs to be addressed, we can communicate to our elected representatives just as any other citizen. I have, in my own experience, communicated concerns in my written work. Just as an example, that resulted in a judicial correction, in a legislative correction, is that I, a year or so ago, granted a motion to suppress evidence that was seized as a result of a search warrant, because there was a gap in the statute. It had to do with issuing a search warrant for information from Google and other out-of-state entities trying to get electronic information. And our statute didn't allow for it. And our state Supreme Court had been very clear what the geographic limits of search warrants are. It was limited to our physical jurisdiction. And so I suppressed the evidence and expressed very clearly that I thought that I knew that what the state was trying to do, but the statute didn't provide for it, and it needed to be addressed legislatively, but I couldn't address it judicially because I had to follow what the law was, and the district attorneys went to the DA's conference and got a legislative fix. So I get a lot of those search warrants now and now I'll sign them. So,
yeah.
So not only did I write my opinion, but I turned away a lot of detectives and said, I don't sign these. So, and they got it fixed. And so that's one way. I mean, you just address it. I frequently in orders about bond will express concerns about the lack of guidance on bond issues. And I think bond is something that I think does need to be addressed, just because I find that there's such a wide ranging, just a disparity in sort of the amounts that are said and the approaches of the different judges. And it's, it seems arbitrary.
Yeah.
But they're those are the only ways that I can think, that may be the best ways in terms of addressing those issues.
So I know that, this is probably a two-part question if I can get there. I know the legislature is always looking at different things and modifications, other things to the system, bail reform, blah, blah, blah. How do they get input from the judges for their opinion? And
the
can
legislature,
they do that?
The legislature?
Yeah,
I think you do. I think that I have seen the legislature has asked judges to provide testimony in front of committees. I mean, I've seen judges do that. It's not unusual.
Okay.
So that's certainly possible. I see someone, one of the comments is asking if we should eliminate bail for misdemeanors. We have a process that allows for a release on recognizance and for misdemeanors. And also we have the sheriff's department runs what's called a pretrial release program, which will allow the sheriff's department, it allows the person to essentially be sort of supervised and notified of court dates by the sheriff's department without the need to put up a money bail. So I would not, not all misdemeanors are created equal. There are misdemeanors that are relatively minor. There are misdemeanors that are more serious. Violations of orders of protection. That's a misdemeanor, but it can lead to some very serious consequences. Assaults, misdemeanor assaults are not necessarily. There are some violent misdemeanors, and there are some misdemeanors that are committed by people with a history of criminal behavior. So again, I'm reluctant to say categorically there should be no bail for particular levels of offenses, but I think certainly we have there are ways we can accommodate for folks that they're charged with relatively minor offenses.
And my guess is that was sort of the way I asked the question, because the legislatures eventually, they're looking at that, whether something changes that or whatever. That's why I ask if it's one of those things that people want to look at. I know there's discussions going on, but in order to get kind of the feel from the judiciary, how does that work? And it sounds like if the legislature were to start looking at that or trying to figure out how to change it or whatever, that would take a lot of people thinking through what the process is.
Right.
Is that a fair way of saying it?
I think that is. And I'm looking at, I've kind of got my chat open. I don't know if you've got it open, Vice Mayor, but
I try to keep an eye on it as you're going through and try to ask questions. Did I miss anything?
No, I'm just looking. I just saw a question about court costs, and there is a process to waive court costs. I actually waive. I don't tell Howard Gentry this. I waive thousands and thousands of dollars in court costs every month. For people who can't afford to pay. I mean, most people who come into criminal court don't have a lot of money. And so if someone's had an appointed lawyer, if someone is living on the edge, I've got a very simple process. Each judge does it differently. But I've got an easy form people can fill out. They will swear, basically have it notarized or come to the clerk's office and sign in front of the clerk. It comes to me and I'll waive the court costs. I waive court costs and jail fees pretty routinely. The only thing that I cannot waive are fines, because the fine is part of the criminal sentence and it's set by the legislature. I do have the authority, and I have in fact reduced fines if I have made a finding of indigence and found that the individual is simply not able to pay by reason of indigence. If I see someone that's coming in and their source of income is Social Security, then I don't think that person needs to be paying court costs. If they're getting government assistance anyway, they don't need to be propping up the government with their government assistance. But
yeah, I get it. Well, I'm looking at the time. We are out of time. This has been very, very interesting. And Judge, I appreciate you taking the time on a Saturday morning. I know there's a lot of stuff going on. This has been really helpful. I hope a lot of people, either if they didn't watch today, will watch, because it's like a primer on how the process works. And you've been great to do it. Really, really interesting stuff.
Well, I appreciate being on. I enjoy sharing it. I think it's interesting, and I think people need to know how the judicial system works, and I think it helps make decisions when they go into these major elections.
I think it's very important. And so, Judge Jennifer Smith, Criminal Court Division 4, thank you. Hopefully it'll warm up this weekend. Everybody can go outside and play in the rain or whatever's going to happen. I know there's a big hockey game outside this afternoon. With the Preds. They're playing at Nissan Stadium. So if you see a lot of action going on, that's what's happening down there. Our next community conversation will be on, I think, February 19th. We're off for 2 weeks. Judge Sheila Calloway, our juvenile court judge, is going to be on there. So it ought to be really, really interesting. So you get 2 weeks off from me. Remember, there's elections going on. You'll see a lot of people running around. Get a sheet, because there's a lot of them, and but this is important. Judge, again, thank you for your time. Everybody, thanks for listening. Everybody be safe and have a great rest of the weekend. All right. We'll see you next time.
Bye-bye.
Thanks.